Calls the case of people versus Zachary Radcliffe.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the people.
The tone is set instantly. Judge Simpson's calm authority signals this is more than routine. When a case begins with that formal roll call, you can almost feel the tension crackle in the courtroom. This is the people versus Zachary Radcliffe, a defendant facing serious scrutiny and a legal battle over probable cause, evidence delays, and a $3 million bond that raises eyebrows. The defense is clearly frustrated by the state's slow handling of digital evidence. 8 videos handed over only days before court. That's not just inconvenient, it's strategic disadvantage. For viewers, this is where procedural fairness meets real human consequences. A locked-up defendant, a pile of unseen evidence, and a judge trying to balance justice with logistics. Stay alert. This hearing will expose how timing and transparency can reshape an entire case.
Your Honor, James Thomas, for Ms. Radcliffe.
Okay, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week. Which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and the $3 million bond was put into place. And at that point, none of
All right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
Never.
But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion.
Judge Simpson lays down the law, literally. No verbal shortcuts. No spur of the moment pleas. The defense must file a written motion. This is classic judicial discipline. Every claim must be documented, every argument traceable. His tone, though calm, carries finality. You can sense the defense attorney recalibrating mid-hearing. Many viewers miss this detail. Procedural rulings like this reveal how judges maintain control without raising their voice. A written motion means the court record will be complete, transparent, and reviewable later. It's accountability in motion. But from a human standpoint, imagine being the defendant hearing this, your freedom delayed by more paperwork. The court's gears turn slowly, methodical, yes, but unyielding.
How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yes, Your Honor.
But the only thing, I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't, if you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on.
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m.
The new date lands January 30th. For legal observers, this is where time becomes strategy. Scheduling may seem bureaucratic, but it's a weapon in slow motion warfare. Each side now gets weeks to prepare, and Judge Simpson wants everything airtight before bond arguments resume. The defense gets breathing room, but also pressure. Any future delays could be interpreted as stalling. Notice how composed the judge remains while juggling schedules, holidays, and travel plans. Courtrooms like this are ecosystems of patience and precision. A single missed date can derail progress, and in high-stakes cases, timing can equal leverage.
That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or
Yes, sir.
my staff.
I suggest we set an exam date.
It's not gonna happen until discovery is all complete. He's saying discovery's not, I'm not gonna do it. What I'm gonna do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set him that way. I'm not gonna set it. I'm gonna hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may never come because it's passcode
And
protected.
then
Now we hit a digital brick wall, password protected evidence. The prosecutor's statement reveals the harsh reality of modern law. Sometimes crucial discovery is locked behind encrypted devices. Judge Simpson acknowledges the problem, but there's little anyone can do unless the defendant cooperates. Here, the tension is philosophical. Should a person be compelled to reveal passwords that might incriminate them? Fifth Amendment questions lurk beneath the surface. Forensic delays can stall justice for months, even years. This moment captures how technology clashes with old-school procedure. Every phone, every tablet can now become a sealed vault in court. The irony, the defendant's silence on passwords might be both his legal right and his downfall. The audience should reflect, in today's system, privacy and justice often collide head-on.
I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's gonna happen. So I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where.
What subpoenas?
No, I didn't say that.
Well, is there other notices out there for anything else that you're doing with, other than his?
I hear that there is electronic devices that are password protected that is gonna take some time to get into, that he may have the passwords to, but I don't think he's gonna give them. So we're just gonna have to wait on that. That's what I'm hearing.
Okay.
Anything else?
No, thank you.
No, sir.
Wonderful. We'll see you on the 30th.
A calm close to the Radcliffe hearing, but don't be fooled. The tension lingers beneath Judge Simpson's polite tone. Wonderful here isn't joy, it's efficiency. He's signaling closure, not approval. The real drama is what happens next. A $3 million bond still in place, pending motions and unresolved evidence issues. For Zachary Radcliffe, this is limbo, halfway between accusation and argument. From a narrative view, this marks the pivot. Procedural groundwork is done. The emotional pressure now shifts to upcoming rulings. For viewers, note how even the smallest exchanges, a thank you, a wonderful, reflect power dynamics. Judges project calm, attorneys decode tone. This courtroom, though polite, is a chessboard. The pieces have moved. Now the waiting begins.
Hey, guys, hold it, folks. Hold on a moment. Who's who with, is that everybody? I just want to make sure. So anybody with defense counsel that was here, they've left already or they're on their way out? Okay, let them go first. I know I try to alternate, but I probably got it all wrong, folks. I'm sorry, but I just don't want anything. Let them go. And then folks, if you would be patient, once they've cleared, then those folks can. Thank you. Court calls the case, People versus Desiree Radnovich.
Yep, right here.
Okay, hello.
Interrupt you on behalf of Ms. Bogdanovich. Judge,
Donovich.
we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have a in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms.
Because she
Bogdanovich,
needs to go in.
no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they
I mean,
told
I've been
me.
sitting in front of the phone for 4 hours waiting for you to call on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay,
tomorrow, 10
Hold
a.m.
on. Maybe he's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
A new defendant enters, Desire Rovic, and the frustration is palpable. Holidays, communication delays, missed calls. What looks simple to spectators is chaos for those inside. The judge's measured patience is striking. He balances empathy with structure. Incarcerated defendants face logistical nightmares when trying to reach counsel. This dialogue underscores a recurring issue in public defense, not malice, but systemic friction. Legal timelines clash with human realities. For those watching, this is a glimpse into the machinery behind justice. Paperwork, scheduling, bureaucracy, all grinding against personal desperation. Judge Simpson's promise to get you heard soon may sound routine, but it's a lifeline in slow motion. Would you stay calm if your freedom depended on the court's calendar?
Okay.
Sorry, your name?
Emerson Wilson.
All right, what, you're requesting an adjournment?
I'm asking for an adjournment, Your Honor.
And we have a new bond violation report.
Yes, Your Honor, I'm in receipt of that. I don't know if a warrant didn't go out.
Pardon?
A warrant has not gone out on the case.
You want me to issue one?
No, Your Honor.
All right, let's address it then.
Addressing it, he does have an appointment today for a medical marijuana card. The last time I talked to him, it was you can't use until you obtain a potential card and seek that permission from the court. That didn't get done quickly. However, he does have an appointment today. He did provide me proof. We're working on negotiating a potential resolution in this case. He understands and can direct to the court that he will not use until.
Has he been using? I mean, and so before you answer, understand, I don't want to call over and get levels, but I will.
Speaking with him, and he's willing to tell the court today as well, is yes, Your Honor. He's been defying the court order. He thought that him obtaining a card was enough for starting that process. But he understands now and will not be using. And I think if we go out to the 30th, the levels will be going down until he gets permission from the court.
Probable cause conference will be adjourned to January 16th, 2025, 9 a.m. This time defendant's bond is revoked, defendant's remanded.
Judge, my client did want me to address one issue regarding bond, if you don't mind.
Go ahead.
Thank you, Judge. I explained to my client the statutory requirements for a child support case and his bond. He wanted to make sure that his bond, to ask the court to set this bond to the lowest possible amount.
Money meets morality. The bond debate reignites, this time over a $3,476 figure tied to unpaid child support. The defense pleads for leniency. The prosecution counters with numbers and dates. Judge Simpson, ever the realist, notes that the bond is already lower than possible. It's a subtle jab, firm but factual. What stands out is the precision of the judge's math. In family and support cases, numbers are justice. Every unpaid dollar carries legal and emotional weight. For the viewer, this is where law meets everyday struggle. Bonds here aren't about flight risk. They're about accountability. Judge Simpson keeps it professional, refusing sympathy plays. This moment shows that the courtroom is not a place for excuses. It's where arithmetic meets authority.
I told him I thought it might be there already, but he wanted me to confirm that with the court. And if not, he wanted to have it reduced to the lowest possible amount.
His bond is set at $3,476, which would mean that he would have approximately owed somewhere in the neighborhood of, I don't know what his current obligation is.
I can let you, Your Honor. I can explain that. His current obligation right now is $15,370.58. That's as of January 6th. He has an ongoing support obligation also of $203. The defendant hasn't made a payment since August of 2023. Technically, the bond should be a little bit higher. It should be about $3,800 right now. But
Right.
I'm not going to make an issue out of that. So
So it is the lowest possible. Thank you, Judge.
Well, it's lower than the
It's lower
lowest
than-
possible.
So it's
Do
not.
you want me to change it?
Not at all, Judge.
Okay, then we're done with that conversation?
We are, Judge.
We are.
Thank you.
All right, bond will continue. Thank you.
thank you, Your Honor.
The other thing is that, I won't address it today, but he may need to appear in person because I've got a violation report from Community Corrections regarding missed samples, 3 consecutive ones.
I actually had a hard time getting to these appointments.
Sir, you might want to talk to your attorney before you start addressing me on that.
Okay.
Positive for THC.
Yes, there was a positive for THC back on December 18th and then 3 successive misses. And prior to that, there was an unable or refuse. So here's what I will do. Sir, you're going to need to arrange to be at the courthouse. We will try to get what information we can to you, counsel, so that you can contact him. But I'll adjourn this out just 1 week to the 16th.
I have a court date on that day.
Pardon?
I have a court date on the 16th at 9:30.
Where?
I'm pretty sure it's going to be at 14.
14-2?
Yeah.
Okay,
Yes,
we're
Your
right down the,
I also
we're right
have
down the street.
Your Honor, I also have 2 other matters that morning. Would it be possible to adjourn 2 weeks?
Well, I think that I need to address his bond violations. Otherwise, I'll just revoke his bond. We'll come get him and then we'll set it whenever everybody can be here.
Judge Simpson drops a warning that cuts through the courtroom air like a blade. His tone stays controlled, but the message is crystal clear. Comply or lose your freedom. This is where his style shines. He doesn't threaten emotionally, he enforces logically. The defense knows the stakes. A missed appointment or failed test could turn a bond into a jail cell. This exchange illustrates why courtroom drama captivates viewers: authority versus vulnerability, law versus circumstance. The judge isn't cruel, he's consistent. The legal world revolves on compliance, not compassion. For anyone watching, it's a lesson in how fast leniency can evaporate when rules bend too far. Would you take that risk for one missed meeting?
Which way do we want to do this?
Well, I understand, Your Honor. We will make arrangements to be there. I'll talk to your court clerk about. coordinating.
Fantastic.
Judge. And I
Probable
do
cause.
have Mr. Tournier's phone number from the chat. So Mr. Tournier, I'll be calling you when we hang up here.
Okay.
January 16th, 2025, 9 a.m. Bond
Thank
at
you.
this time. Bond at this time is continued. Thank you. Court calls case of the People versus Kyle Rainey.
Assistant Public Defender, Julie, Your Honor, on behalf of Mr. Cal Rainey, who is approaching.
That's what I was looking for. Why? Go ahead.
Your Honor, today is the date and time set for probable cause conference in this matter. I know the court would want to first address Mr. Rainey's bond violation.
Yes.
I know. So, Your Honor, Mr. Rainey was released from custody. I don't have the date in front of me. However, upon his release, Your Honor, he
left the state.
he did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing. To our community.
No, not serious.
Okay. He is, Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to
I
go.
ended up getting in Litchfield one day.
Okay. He indicated that he was
You
only
need to take your hands out of your pockets.
He indicates that he was only in Indiana for 1 day. He has been back now.
1 day too long.
1 day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield.
Litchfield, Michigan, where I'm from.
In Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously. We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved first. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
No, he knew then.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact, and I apologize.
No, you didn't contact everybody you could have contacted. And you didn't get a response. Any response from the people?
The concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else, he was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not, but the issue is, he was on bond for a CCW at the time of this possession case. He leaves the state. And I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And if there are, clearly had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was gonna follow the bond conditions that were set by the court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she forwarded the testing results to community correction. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's orders. It's really simple. Anything else?
Like I said, I got a place here.
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time, the defendants remanded on the warrant. Community correction for violation of his bond.
Thank you, Your Honor.
The gavel comes down figuratively. Judge Simpson orders the remand. Calm, procedural, absolute. Another day, another defendant learning that courtroom mercy is earned, not assumed. Across multiple cases, Radliff, Rovick, Wilson, Rainey, one theme stands tall: accountability, discovery delays, password battles, child support, and cross-state bond violations. Each thread weaves a portrait of modern justice under strain. Simpson's steady hand keeps chaos contained, proving that patience is power in the judicial seat. For the audience, this wasn't just legal drama, it was a crash course in consequence. Every decision echoed beyond that wooden bench. If you found this case as gripping as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns right here on Trial Truth.
That kick to the groin. The officer says it happened. The defendant says otherwise. These tiny seconds of video will decide whether this stays obstruction or becomes assault on an officer.